Greetings from Vancouver, BC. My name's Joe Weiler. I'm a professor emeritus at the Peter A. Allard School of Law at the University of British Columbia. And I'm co-director with my friend and colleague John Ritchie of the Anti-Corruption Law Program, which is a joint working partnership in providing continuing professional education. And the partnership is between the Centre for Business Law at Allard, Transparency International Canada, and the new Vancouver Anti-Corruption Institute, which is affiliated with the International Center for Criminal Law Reform. This is the 32nd seminar since we got going, actually 6 years ago this month. And it's an example of how three leading organizations, all with different core competencies, but with the same common mission and doing what we can to fight corruption. And it's an example of how organizations can take collective action to work together, in this case, to provide top quality continuing professional education. And the way that we do this is by bringing together leading experts in the field and where we teach each other about the best ways to fight corruption. Now, this is the first session of a four-part series on the Cullen Commission Report. Way back when we were planning our roster of events for 2022, we had penciled in one session on the Cullen Report back, and we thought June, July, just after the report was published. But now we know that the Cullen Commission report warrants much more than one session. And it's a deep dive into money laundering in British Columbia, where the commission heard from over 200 witnesses over its lifespan of 2.5 years. The report is 1,800 pages and is produced very well thought out and 101 recommendations. It's really a watershed event in Canada, in our view, about coming to grips with money laundering. So this past summer, the three partners, we put our heads together and we have now designed this four-part series. It's a bit of a mini course on the Cullen Commission Report. Today's focus is on the report's recommendations with respect to the private sector and self-regulation. Next month, October 31, Transparency International Canada will take the lead in hosting the second session on creating more transparency and beneficial ownership, corporations, trusts, real estate. November 22nd, the Vancouver Anti-Corruption Institute will lead a discussion on enhanced anti-money laundering tools, and as recommended by the Cullen Commission. Tools such as unidentified wealth orders and enhanced civil forfeiture. January 19th, where the organizations were putting our heads together, and we'll collaborate on the institutional reform measures, in the Commission's report, the proposed anti-money laundering commissioner within the government of BC, the dedicated intelligence and investigation unit, the BC Financial Reporting Agency. So what do those look like and how do they interface with agencies of the Government of Canada, such as FinTrack and their proposed Canada Financial Crimes Agency. So I'd like to give special thanks to Carol Liao and her crack technical team at the Center for Business Law, who are fantastic support for this program. James Cohen and his team at the TI Canada, Dr. Peter German at the VACI and iClear, and thanks in advance to our panelists. And it's now my pleasure to turn things over to Norm Baldwin. Norm is a senior partner at GRC Vista Risk Consulting. He's got decades of high-level experience in consulting with respect to anti-corruption investigations and compliance in Canada, Latin America, and Africa. And he plays a very important senior advisory role within the anti-corruption law program. So thanks, Norm, for all you do for the program. And now it's over to you.
Well, thank you, Joe. Okay, fantastic. So as Joe mentioned, the anti-corruption law program is connected with the University of British Columbia. So we would like to acknowledge with gratitude that its campuses in Vancouver are situated on the traditional unceded territories of the Musqueam, Squamish, and Tsleil-Waututh First Nations, while UBC's Kelowna campus is in the territory of the Sayilks Okanagan Nation. Now, this webinar is being recorded and will be available on the CBL website and on the Anti-Corruption Law Program LinkedIn page. For those of you who want to see and hear a recording of this later on, it will be available to you. Also, if any listeners out there today, anybody in the audience have any questions, please feel free to send them in through the platform, and we will get to them as we can. So please take full advantage of our panelists today by asking them whatever questions you would like. As Joe mentioned, the Cullen Commission was established in the wake of significant public concerns about money laundering in British Columbia. Its mandate, quite simply, was to inquire and report on money laundering in British Columbia, and it did that job quite thoroughly and comprehensively. As you heard, this is the first of 4 seminars about money laundering in British Columbia and on the findings and recommendations of the Cullen Commission and how those will impact money laundering efforts in British Columbia, Canada, and beyond. So after all of that, let's get this webinar started. We truly do have a star-studded panel with us today, composed not just of anti-money laundering experts, but more importantly, people who have more knowledge and insight than probably anybody on how the Cullen Commission hearings were put together and what their results might mean for British Columbia. First off, we are indeed fortunate to have Brock Martland, who was one of the 2 senior counsel for the Commission, which means that he not only sat through 133 days of hearings, but also had the opportunity to question financial crime experts from around the globe. Joining Brock today will be David Averin, who's the Vice President Legal of the BC Financial Services Authority, which regulates numerous private sector industries here in this province. Don Avison, who is the Chief Executive Officer of the Law Society of British Columbia, which is the regulator for lawyers in this province. And finally, of course, we have Peter German, the former Director General of the Financial Crime for the Royal Canadian Mounted Police, and more recently, best known as the author of the Dirty Money 1 and Dirty Money 2 reports on money laundering in BC. And incidentally, David, Don, and Peter were all among the 199 witnesses who testified at the Cullen Commission hearings. Now, although I personally am from British Columbia and from Vancouver, I've spent many years investigating corruption and financial crimes in Brazil, including money laundering. Luckily, my work in this field is made easier because so many of the predicate crimes in Brazil take place in that country, and that is somewhat different than the situation we face here in Vancouver and British Columbia. And just as by means of explanation, predicate crimes are those illegal activities which generate the money that the crooks are trying to launder. And starting back in the 1990s, on my regular trips back to Vancouver, I began to hear more and more about how money laundering was becoming rampant in Vancouver. And with each passing year, I was hearing people claim that that particular mega mansion is proof of money laundering, and those Lamborghinis parked in that driveway are money laundering, and the runaway property prices in Vancouver, that's proof positive of money laundering, even if people didn't really know what money laundering was specifically or how it worked. But it was getting to the point where I just couldn't even pick up a newspaper without hearing about money laundering and how it's ruining everything in Vancouver. And so what happened after that? And so at this point, I would like to turn things over to our fifth panelist, Christine Duhaime, to not only pick up the story, but to fill us in on the history of how things got so crazy and what was eventually done about it. Christine, by the way, is an internationally recognized authority on anti-money laundering compliance and a financial crime expert with Fusion Intelligence. So Christine, welcome. Sorry, I'm a bit out of breath after frantically trying to get online with all of you, but I'm glad I'm finally here. I'm glad all our panelists are here. And Christine, I'm really glad you're here. I know you're an expert and a historian of money laundering in British Columbia. So can you please take us on a brief tour of how we got here?
I think good morning, and thank you for the kind introduction. I was on mute, I didn't realize. So I'm pleased to be with you. Anyway, yeah, so I was asked to give a little bit of an overview on how it is that we ended up with a Cullen Commission from the perspective of the noise and from the perspective of sort of what was happening behind the scenes with respect to money laundering in British Columbia. And I'm happy to share later on for attendees the PowerPoint that I did. It's just a 2-point kind of timeline that shows, kind of the newspaper articles and what happened behind the scenes. But really briefly, one of the points that I think we need to keep in mind is that we didn't suddenly in 2014, 2015, 2016 have a problem with organized crime and money laundering in British Columbia. In fact, I found an old case in 1944, surprisingly, but I guess not so surprisingly, where the first Mexican cartel, which was run by a woman, she ran opium through the United States in the same corridor they use today, up through Vancouver, sold opium down to Vancouver and then washed the money back in the United States. And the very first precursor to the DEA got involved and shut that down, arrested some Canadians out of Vancouver. So I thought it was an interesting point to show that really we're kind of at the same point we were in 1944 with, organized crime, Mexican cartels coming to Vancouver, laundering money from Vancouver into the United States, back into Mexico. So things change, but, they don't change to some respect. And then if you kind of go through the history, like any other big city or, a small city back then, Vancouver, I think because of its location, just because of its nature, was always a place where, we had some measure of financial crime going on. And with those serious predicate offenses, of course, we had money that needed to be laundered in some way or another. But I think things really started to happen with respect to Vancouver becoming more of an organized crime center. Probably around the late 90s, there were a number of organized criminal gangs that set up and did a lot of kind of an Indo-Asian community, where a lot of drug trafficking began to take root, as well with the Hells Angels. And again, all of that money needed to be laundered in some way or another. We had some really high profile indictments. People probably remember the indictment and arrest of Ranjit Chima. He was from Surrey and he was a leader of an organized crime group. And I think 6 or so of his alleged organized criminal associates were extradited and arrested in the United States for, I think at that time, one of the largest importations of heroin from Afghanistan. So that was kind of a big case that made the news in Vancouver. A lot of those guys then got released, not uncoincidentally, ended up, coming in front of law enforcement again for other things, including to this day, unfortunately. So then we had in Toronto another big international case that touched on Alberta and touched on British Columbia, and it was the YMB magnets case. I don't know if people are familiar with that. It was this guy named Mogilevich, who is an oligarch from Ukraine on the FBI's most wanted list. The connection to British Columbia is that they set up a public company that became an issuer and used the Canadian capital markets. And they laundered the process of crime from human trafficking, from weapons trafficking in Europe and out of Russia and the Ukraine in our Canadian capital markets. And one of their people that joined them on the board of directors and was, probably an unwitting facilitator, but nonetheless assisted in some way, was a British Columbia capital markets guy. So after that, we had a number of different high-profile cases. Operation Bermuda Short, Peter probably remembers that one. Again, it was an international case, very much tied to British Columbia. A number of people were indicted, including a guy named Martin Chambers, who is quite well known, who was their alleged facilitator, did some time in jail, I think is now out. So then around that time in Vancouver, probably not too well known to most people, is that the Association of Anti-Money Laundering Professionals, which is an American organization, set up a Vancouver branch. So for about a 2 to 3 year period, I think Peter came to speak at one of our events. That association did a lot of organization and a lot of information gathering and a lot of stakeholder gathering to try to figure out what was going on in Vancouver and to try to educate each other in a lot of different areas. One of the key areas that we looked at was money coming from China and whether or not that was process of crime. So we did a lot of sessions on that. We looked at immigration fraud and wealth coming in from China specifically and Iran. We looked at Bitcoin. We looked at a number of kind of key touch points that people in the industry, in terms of those that were facing, potential process of crime, were looking at in terms of things that were coming up again and again. So there was this growth period, if you want to call it, where different people from different stakeholders got together and tried to create an ecosystem where we had shared knowledge, where we could educate people on anti-money laundering. And then that led to a proposal to the federal government to create a financial crime center in 2015 in order to be part of the budget 2015. The minister at that time, Joe Oliver, was supportive, had a lot of discussions on what that would look like, political discussions, where it would be situated. I think Toronto was obviously the place, but at least from my part in those discussions, I was coming from a place where I thought Vancouver would be ideal and could use the assistance for sure. At the end of the day, Stephen Harper nixed it, unfortunately, but it was a really good idea. I still think lots of room for that. And then kind of another wave happened right after that, where Vancouver was seen for a short period of time as a place where there was a lot of anti-money laundering expertise, where, probably might surprise a lot of people, but Citibank held a conference there and people in financial crime spoke about financial crime mitigation. And a lot of different organizations, including FATF, reached out to people in Vancouver in terms of understanding what the friction points were and where there were gaps and ways in which, mitigation for financial crime could take place, and they could lead upon the expertise of experts to move the needle in terms of stopping financial crime globally. And then there was a bit of what I call a watershed moment. I think there were a few watershed moments, but one of the ones that I think cut really deeply into the AML community and into people that were stakeholders, and I think really around the world, but I don't necessarily know that it was, that people realized how much of a kind of turning point it was, and that was the PACnet. And PACnet was a payment processor in Vancouver, and they were a global payment processor, I guess a little bit under the radar, at least for those people in the ecosystem. Was based in Vancouver, also had a base in Ireland. And what happened was OFAC listed them as an entity, and the US Department of Treasury came out and said they were a money laundering organization. And the money that they ran through their payment processor, which means through Vancouver banks, right? That was all process of crime. So that was really a shocking moment for people in the anti-money laundering community. Not least of which one of their members was a member of our ACAM's board of directors. So I think we all were a little bit shocked by what happened there. Things are visible but not visible, even if you're in the space, in terms of what's going on perhaps in your own backyard. So that was a watershed moment for a lot of people with respect to getting attention onto Vancouver as a place where we may have been saying there was a lot of money laundering going on, but here was kind of a way more definitive external foreign agency that deals just with financial crime saying, okay, Vancouver, you have a problem, at least in respect of this particular entity. It's so severe and nothing's being done that we're going to list it. So that was kind of our internal watershed moment. And then I think a lot of media attention began to be focused on Vancouver. And you probably saw, maybe noise, so maybe a bit more fiction than fact, we really don't know, but a lot of noise about Vancouver as a money laundering hub, a Bloomberg article, a Wall Street Journal article, New York Times, you name it. They were saying Vancouver was a money laundering hub. And then former Minister Eby released the famous videotape, where I think we all could imagine in our mind of, I think there were two people in the videotape, and it showed them going into the cash cage at River Rock Casino. So the cash cage, if I'm not mistaken, it belongs to the BCLC, a government agency. And so it showed two patrons of the casino going into the BCLC's cash cage and just dumping bags of cash that were bundled. I think they were buying in for chips, but it really wasn't clear. So I'm backtracking a little bit just to say that before that time, people like, Richard Kurland was communicating with the federal government about, what he saw as some issues that needed to be looked at. Other people were communicating with the federal government, perhaps with the US government on the securities fraud side, on problems that they were seeing in British Columbia. So then as a result of all these headlines, and I think Peter probably is way more versed to step in and talk about what happened at this point, but then there was a lot of noise and a lot of fact and fiction and a lot of pressure on Minister Eby to take some action. And I think he was self-motivated as well. I know that before he ran for election, he certainly reached out to a lot of stakeholders and had some discussions on, when and if he were to become elected, what are some of the things he could look at. So, then I think Peter did his two reports, and I think all of that pressure that was political, that I think was coming from even from stakeholders, that was coming from the voting public, and that I think this public attention on whether or not British Columbia was a problem. I think we all know that there were some concerns, but I think the issue was British Columbia a problem out of proportion to other areas, right? Was there a unique British Columbia problem that needed to be looked at? And then Peter issued his two reports, and then there was one other report from, I think, the Minister of Finance. And then we had our Cullen Commission with the great number of recommendations that it has made. So there you go. That is sort of a brief history on what happened leading into our Cullen Commission.
So money laundering is hardly something new here in British Columbia, and I think anybody who's lived here for any length of time would certainly be well aware of that. Peter, Christine mentioned the hockey bags full of cash at the River Rock Casino. I was actually in the River Rock Casino the other night. I went there for the famous buffet dinner, and I walked through the casino afterwards, and I was trying to visualize how people would have actually walked in there with hockey bags full of cash without anybody really raising eyebrows. Was that sort of the turning point for the dirty money reports? Was that what really kickstarted your efforts from the provincial government?
Yeah, well, thanks, Norm. I appreciate the question, and I'll just build on Christine's comments. But before I do that, let me just congratulate both Joe and John on 32nd session of this ACLP series, which is really fantastic, and brings the issue of money laundering to a pretty wide audience. And thanks to the virtual world we live in, that audience now is literally around the world. So kudos to both of you and to the partner organizations. I think Christine is, bang on in terms of, Vancouver is really a long way from everywhere if you're in Europe, Africa, Asia, but ironically, it is actually very close in many ways. And just to summarize some of the points that Christine made, location here is pivotal because in many ways, Vancouver is an Asian city. We look to Asia as opposed to the rest of Canada. We also are right beside the US border, which makes it critically important from a perspective of organized crime. All the things that make Vancouver a lovely place to live also make it very attractive to organized crime. Add to that we have very large diasporas, very dynamic, active communities, but every community's got its own form of organized crime. And I will pick on the Caucasian community. The Hells Angels have made Vancouver a playland for many years. So you've got all these ingredients. Plus, we've got a culture out here. It's often called the California of Canada, in that soft drug usage has been accepted for many years. Vancouver is now looking at an exemption from the federal government with regard to hard drug usage. So we've just got a culture that allows organized crime and drugs to proliferate, in my opinion. In terms of more your specific question, there's definitely this buildup. There was a lot of attention in the media to what was taking place, as Christine mentioned, and it wasn't only the print media, the TV stations and so forth were looking at what was happening in the casinos, and they were suggesting that there was money laundering. And we also know that various members of the bureaucracy in the gaming regulator were also concerned about what was taking place, but it required somebody to do something. And although various people were working within the system, as Christine mentioned, the current Attorney General and quite possibly the next Premier of BC, when he was in opposition, was concerned by the media reporting that he saw. And when he became Attorney General, one of the first conversations he had was with the gaming regulator. They asked to meet with him and essentially showed him the video that Christine is talking about and told him about their concerns. And that then led to him asking me to do a report, and that was Dirty Money. And then there was a subsequent report, as Christine mentioned, on real estate and automobiles and horse racing. That was Dirty Money 2. Maureen Maloney did another one with her team, which concentrated on the real estate industry. And there was yet another looking at the financial industry, which David is probably better informed to speak about. So, these concerns that have been out there for many years had finally found, in many ways, a champion in Attorney General Eby, and away we go from there. In many ways, the public, as this process is underway, is becoming more and more alarmed. And as I recall, after the various reports were submitted, a form of survey took place, and it looked overwhelmingly that British Columbians wanted an inquiry or commission, and that is exactly what the government ordered. Brock, again, is the expert in terms of what the Cullen Commission did, and hopefully we'll have a chance a little later on to comment on the recommendations. Safe to say that in my respectful opinion, the Cullen Commission is much more than about British Columbia. Yes, it made about 100 recommendations, many of them relevant to BC, but from my travels in recent days and weeks, it's very clear that the knowledge of this commission report has really traveled to various continents, simply because a lot of experts in money laundering from around the world were called as witnesses. So they're very familiar with the report. Plus, it is unique in that how many public inquiries, royal commissions, you name it, have looked at the issue of money laundering. You just can't find them. You will find specific reports on, let's say, the casinos in Australia, or you'll see reports on what's taking place in the UK, but not specifically money laundering. And that, I think, is what makes this so important and gives it coverage or importance outside of British Columbia. I'll stop there.
Wonderful. Thank you so much, Peter. And I think all of British Columbians owe you a debt of gratitude for all the hard work and research you did in getting those 2 Dirty Money reports out into the public eye, and certainly into the global public eye, because it's put us on the map. It's put you on the map, but it's certainly put British Columbia on the map. And I'm hoping that it has really kickstarted some activity in Victoria and in Ottawa, to really improve and strengthen Canada's anti-money laundering regime. And just moving on with this idea of Victoria, Dawn, I know that you mentioned that the provincial government is now entertaining the idea of implementing a provincial regulator for lawyers, registered paralegals, and notaries. How's that going to affect your activities with the British Columbia with your group here in BC?
Well, thanks, Norm. I think a lot of people that are watching the program are perhaps not aware of this because it's a relatively recent development. It was only about a week ago that the government posted on their website an intentions paper with respect to the possibility of creating a single legal regulator in British Columbia that will have responsibility for the regulation of lawyers, of notaries, and of paralegals. And we're in early days in terms of the development of both the concept, the governance model, and the statutory mechanism that will facilitate that. So I think it's something that members of the legal professions, all three of them, will want to take some time to have a look at. Certainly, it'll have implications in relation to the kind of work that will have to be done to put all of that in place, about how it might distract or divert us from the work in relation to anti-money laundering initiatives. My answer to that question is not at all. I think we've got quite a robust structure when it comes to the investigation of matters that are within the current jurisdiction of the Law Society. So the investigations group and our audit group will continue apace in relation to the obligations that they have in that regard. So I'll perhaps say a little bit more about this at the end in relation to what I think some of the potential might be for a more unified approach in relation to AML activities and initiatives across all three of the legal professions of British Columbia, particularly with respect to some of the opportunities that exist on the educational side.
Yeah, definitely. I want to be moving in on exploring more rather of that topic and how lawyers are being educated and trained here in British Columbia to recognize money laundering and what to do when they do recognize it. So that's certainly something that I do want to explore as we move forward in this webinar. I want to move over to David Avron now, who's Vice President of Legal of the British Columbia Financial Services Authority. Dave, this is a sort of a new entity, although it comprises a number of pre-existing entities, which have all been sort of rolled under one roof now. And I think a lot of British Columbians probably aren't aware of that, and maybe aren't quite aware of, and if they are aware of the BCFSA, they might not be aware of everything it's doing. So can you sort of let us know about what this new regulatory body is all about?
Yeah, thanks, Norman, and good morning, everyone. And listening to Dawn, one of the, I'm tempted to say flavors of the month, but one of the contemporary themes in regulation is consolidating regulators, health services, for example, and meta regulators, a regulator over top of regulators, as well as something called light touch regulation. BCFSA in its current state is really only a year old, year and a bit, August 1st, 2021. It was the product of a merger between what was called BCFSA and the Superintendent of Real Estate and the Real Estate Council of British Columbia. Long history to all of these things, going back a little farther because it is a complex history and with a complex mandate. The BCFSA, as it was a year ago, was really the old FICOM, Financial Institutions Commission, which was embedded in government and part of government, had been there for a while. And it had responsibility for regulating credit unions, pension plans, insurance companies in British Columbia, and trust companies, as well as mortgage brokers. And the Superintendent of Real Estate had a role supervising real estate developers and a sort of supervisory role with the Real Estate Council. Real Estate Council regulated real estate agents. Those are the people that buy and sell real estate, but also the people that do rental property management and strata management. So all of these were brought together in just over a year ago and merged. The BCFSA had been created, sent out of government as a Crown agency just a couple of years before that. So it's been a very busy time for those that came out of FICOM into BCFSA from one Crown, creating an independent Crown agency to a merger with these other bodies. The mandate is complex. There are 10 statutes. So as I say, it's those credit unions, pensions, insurance companies, trust companies, mortgage brokers, real estate developers, and real estate agents. And I've heard that really, as a financial regulator, it really touches on, in effect, 25% of the provincial economy. That's pretty rough and ready, but it gives you an idea of the potential scale of the thing. It's both it regulates professionals in the way that the Law Society and the notaries do, regulates professionals, would be the real estate agents and the mortgage brokers, and regulates institutions. Those things are similar, but they're not identical. When you're regulating professionals, it's fitness for entry, it's setting standards, and it's discipline, principally. Other things as well. With regulating industry, you're looking at, or institutions, you're looking at risk and stability, health of the industry, protection of the public in a broader way, and managing that risk. They have elements in common, professional and institutions by audits and monitoring and so on. But there's a lot more disciplinary work with respect to professionals. AML, anti-money laundering, currently is very much a part of what the BCFSA does. It's integrated into the credit unions, for example, as part of the regular risk assessment. And in that regard, we were able to draw on some of the sophisticated work that the federal counterpart, OSFI, the Office of the Superintendent of Financial Institutions, does. And we continue to use OSFI's guideline B8 in respect of anti-money laundering and credit unions. On the professional disciplinary side, realtors are reporting entities, mortgage brokers aren't present, but realtors are. And we do work with FinTrack. We can probably talk about that later, but we would be looking to see whether we've received complaints, and if those involve money laundering, taken very seriously. It's one of a number of potential offenses, of course, that would be relevant to their discipline and their continuity as professional or their relicensing. It might be sort of first amongst equals, but it is one of a whole series of things like criminal code offenses as well. One of the hopes of this merger, bringing together all these financial regulators, which incidentally have a bit of a counterpart in Ontario with what's called FISRA, is to share data between the parts of BCFSA. And to some extent that's possible. To some extent that is not possible where it involves personal information because of restrictions under the Freedom of Information Protection and Privacy Act. Sometimes that's overcome if there's a specific investigation or it's a licensing matter, but in a general way, for the routine stuff, it's not possible if it's personal information. I'll just finish answering your question, Norm. I've probably gone on a bit long. With a few rough statistics, I say we touch on about 25% of the provincial economy. There are 27,000 real estate agents in the province, 1,300 brokers. We received about 400 complaints respecting real estate agents in 2014, 2015. It's 3 times that now. It's more in the order of 1,200 annually now. And of the current crop of complaints, only about 10 pertain to money laundering. I'm not familiar with the details of them. Those are in our investigation group. They could be actual facilitation of money laundering. More likely, the preponderance, if not all of them, would concern compliance with anti-money laundering initiatives at brokerages. So leave it at that for now, Norm. I probably got the answer to your question somewhere in there.
No, that was terrific. And I note that of all the industries that the BCFSA regulates, all of them came under scrutiny by the Cullen Commission, and all of them received recommendations as well. Realtors, credit unions, mortgage lenders, et cetera, et cetera. So I'm glad you pointed out that all of that information and certainly those numbers. How many credit unions, by the way, do you currently cover in British Columbia?
There's a little under 40. That industry is consolidating.
Right.
Some are looking at going federal. One did, of course, Coast Capital. And yeah, it's 40, but it's over 10%. I don't remember what the statistic was. I was head of legal at Coast Capital for a time. It's in the order of 15% of all the deposits in British Columbia. Most are, of course.
That's a lot. That's a lot of money.
It's a lot
of money. Yeah. And now, finally, we turn to the man who was in the hot seat for all those many, many days during the Cullen Commission hearings, Brock Martland. Brock, Peter mentioned that there's been various public inquiries, commissions, et cetera, in other countries and even here in Canada that have sort of danced around the issue of money laundering but have never really addressed it specifically. How did a public inquiry like this in British Columbia really get off the ground, and what sort of differentiates the Cullen Commission, from some of these other ones that Peter mentioned.
Yeah, thanks, Norm. I think public inquiries are strange creatures, and there's probably not a broad or at least a shared understanding always of what we mean when we use those kinds of words. The lingo in this country for a long time was royal commission. You'd hear that thrown around, and that's mutated over time to become public inquiries. At a basic level, I think you can distinguish that from things like consultations or reviews, which I think is a term that I don't know if Dr. German would endorse that, but I think that's the way his work was described, as independent reviews to the provincial government. A commission of inquiry, for better or worse, has as its model that a retired or sitting judge, and in our case, the former Associate Chief Justice of the Supreme Court of BC, Austin Cullen, comes in with fresh eyes and receives and gets evidence and has people in the room as parties or participants. And it's sort of an analog to a trial. It looks like a trial, but it's not actually a trial. Luckily, or for better or worse, we don't have rules of evidence to the same level. We work our way through that process with the aim to provide the basis in evidence for the commissioner to make findings and recommendations. I think the remarks earlier are quite accurate in saying, well, this commission is different for a few reasons. One of them being, most commissions come out of one particular sad incident. So as an example that we know in Vancouver, Robert Jakanski's death at the Vancouver airport after he was tasered. That led to quite a prominent public inquiry by Thomas Braidwood. In other cases, the Walkerton tainted water inquiry. Right now, there's something called the Mass Casualty Inquiry, a joint federal provincial inquiry going on in Nova Scotia into the horrible events with the multiple killing that occurred there a few years ago. And our inquiry is not unique, but I think distinctive from most in that the focus was not, here's an incident and let's hear evidence, much as you would in a trial, and let a judge make findings of fact about the incident and then step back and take conclusions about what to do. Instead, this was quite a sprawling mandate. And the commissioner is essentially told, well, there's your mandate, and you're independent of government, of all government. You're given the mandate and the time and the budget to head off and do the work and report back to the provincial government with recommendations. One of the distinctive things here is that was a very sprawling mandate encompassing a huge chunk of the province's economy in any number of sectors. And the challenge for us in part was to figure out, where could we tell a story, where could we lead evidence, but also get the ship back to harbor without disappearing for a decade. So I think at a general level, that describes the sort of process and what we set off to do. And as we've heard about prior reports, two of them by Peter German, the report by Professor Maloney and her colleagues, a further report by Ben Perrin, those were all there as backdrop and indeed included in our terms of reference. So we didn't start at mile 0. I don't know if we started at mile 10 of our marathon, but we certainly had a jump start given the work that had already been done quite recently.
Terrific. And what sort of assistance or / barriers were you confronted with sort of right at the very beginning when you were getting this off the ground?
So we ran into, and I think it's commonplace that inquiries hit some stormy waters here and there. On the plus side, we got through it despite the pandemic, and we, touch wood, haven't had a judicial review or anyone marching off to court to challenge things we did. That didn't happen during the inquiry. It hasn't happened since. On the other side, we did have to cope with the pandemic. We had to figure out, there were delays that arose because of that in part. We've had, I would say, a delicate set of interactions with the federal government. This is a provincial inquiry. Unlike the one I referred to a moment ago, it was not ever made a joint provincial federal inquiry, and midway along our lifespan there was a federal election, and one of the major parties had been taking a platform position it should become a joint inquiry. That didn't happen. We had no interest in that, but it certainly would have affected us to be told that it was federal. The federal government was a participant, meaning they had party status and they had a team of lawyers that were very actively involved. They furnished a great number of witnesses and documents. On the other hand, speaking for myself, they were careful about their engagement. And our inquiry website has a whole, probably an overload of materials about money laundering, including the closing submissions of the party. And one measure of that, or proof of that, is the closing submissions of the federal government go on at some length to say, Mr. Commissioner, here's all the restraints on you. Here's the constitutional and jurisdictional limits on you, because you're not a federal commissioner, and you shouldn't head off to make findings about the internal management of, let's say, FINTRAC and other federal agencies. I think the commissioner articulated his view that it was necessary to make findings about federal entities and the federal regime in understanding and making findings about what happens in BC. So he did that and was critical, I think it's fair to say, of the FINTRAC reporting regime and to some extent the RCMP federal engagement on these issues. But it also means that the report is quite oriented at the provincial government. So you have recommendations that are very much geared at the provincial answer. And yet, I think it's fair to say in many cases, the ideal outcome would not simply be a BC answer. It would be ideally a collaborative, but especially a federally led response to a number of these issues.
And did you get any pushback? Again, you were mentioning, I do appreciate the word careful that you mentioned. Did you get any pushback from the careful federal government on the very low number of FINTRAC reports which finally make their way to law enforcement in British Columbia?
You know, offhand, I'd have to refresh my memory a bit more by going back in evidence, but my recollection of some of the language and findings and the evidence around the FINTRAC, and we had people like Nick Maxwell, who wrote an expert report who talked about it and described this as being high volume, low value. And he had an incredible statistic, was something to the extent that per capita, Canada's reporting is about 10 times the Americans and about 96 times per capita the rate of reporting that you have in the UK. So that's a model. Now, I think the report takes some pains to say that's not a failure of the people who are at FINTRAC. If anything, it's a design failure that you have a regime that says, we'll separate out where FINTRAC is situated. They're not tied in and integrated with law enforcement the way they are, for example, as I understand, in Australia and New Zealand and other parts of the world. And we will give them a set of rules and restraints that are designed to protect the flow of information for sound reasons. But as a result, the people at FINTRAC are sort of given a particular design and they operate within it. I think at some extent the commissioner was trying to ask more normative questions about, is that the right model? Is that how we should be approaching these things? And if the federal model is ineffective, is there a need for a provincial intelligence response that comes to grips with the sort of real world situation a bit better?
Understood. Wow, that's quite an amazing set of statistics, actually, about the number of reports FINTRAC generates each year. It's a massive number. Whether we're getting the desired results out of all of that is probably a topic for another day. One of the goals of this particular webinar is to try to assist the private sector in adopting, at least analyzing, and then hopefully adopting some of these recommendations and findings of the Cullen Commission. And all of you really have been involved in some form or another and will be over the next while in assisting the private sector in strengthening their own anti-money laundering profiles, hopefully based on some of the recommendations and findings of the Commission. I'll go back to Christine on this. When we had a little get together of all the panelists on Friday, and Christine, you were really harping away on education as really the first step that private sector agencies and organizations can take. Do you want to sort of expand on what you're doing and how you see the recommendations of the Cullen Commission being incorporated into a learning program that organizations here in BC can adopt?
Sure. I think I would start by saying something that I think I said for a number of years, which is that when we talk about money laundering, and I think this speaks to the Privacy Commissioner federally and what FINTRAC itself has said in the past, which is that although maybe there's an issue with respect to the quality of disclosure that FINTRAC is compelled to give under the legislation or that is asked to give. So irrespective of the quality of that disclosure, I think what happens with FINTRAC is that it receives an enormous amount of reports, some of which really are not actionable from their perspective because people don't really understand the idea of your reporting a suspicious transaction that is tied to a predicate offense. Not everything is going to be a predicate offense. And I think that generally speaking, even in the reporting sectors, for example, the banks, casinos, somebody may come in with a large bag of cash, but when you're filling out a suspicious transaction report and you're going to make a filing with FINTRAC, you need to identify what predicate offense you think that is. And just because someone has a bag of cash, it doesn't mean it's tax evasion. It doesn't mean that they're a money launderer. So I think one of the difficulties where I think education comes in is, what do we mean? Like, what is the predicate offense that triggers the reporting of a suspicious transaction? And I think one of the big education pieces we need to focus on is those are the serious offenses. So they're enumerated in our legislation. They're not what you might necessarily think. And so I think if we could educate the reporting entities and just educate the general public as well to understand that money laundering really is quite a specific activity tied to quite specific enumerated offenses. Could be murder, could be fraud, could be a Ponzi scheme, could be, immigration fraud. There are a number of very serious ones, tax evasion being one of them as well. But what happens with FINTRAC is what they receive is information that from a bank, from a credit union, where somebody came in and, they reported it because the person at the front-facing customer person is suspicious about the customer, but they're not suspicious in relation to a predicate offense. So, that's information that FINTRAC may receive, but to the extent it's actionable, I think is questionable. I'll give you an example of a credit union, because Norm, you asked us for specific examples without naming names. So a credit union, we do sometimes what are called lookbacks. What a look back is a reporting entity will come and say, can you look back for our due diligence purposes or for our compliance purposes that with respect to all of these, this set of transactions we had in this period, did we report to FINTRAC properly? Do we need to self-disclose in case we didn't report? So, reporting entities will always do a look back. So you look back with fresh eyes on their activities and you decide for yourself to report back to the client whether or not there was instances where they should have reported or should not have reported. So I just vividly remember one case where a credit union had a customer that came in. The customer self-identified as a member of the Hells Angels. He was going to Los Cabos, which is where the Vancouver Hells Angels happen to have their, house number 2. So, I think those are things that are known in the Vancouver financial crime world. A lot of Hells Angels activities and where they go for their summer vacations or winter vacations, or, that type of thing. Anyway, so this customer came in and with a lot of cash, was going to Mexico, was a Hells Angels, and that didn't get reported to FINTRAC. And you're kind of like, I feel like that's a lot of red flag. So what's the predicate offense? Well, could be money laundering, could be drug trafficking, could be, member of organized crime. So I think that's one example, right, where I think a report to FINTRAC could have gone, but didn't go. And I think the person in that instance didn't really understand tying a predicate offense to a suspicious transaction. In fact, didn't file a suspicious transaction report. So I think education, to me, that's an example of education of both fronts. What is help people understand that this activity is tied to predicate offenses? What are they? And then when you can enumerate them, then FINTRAC, I think, has better actionable intelligence to then flow it back to law enforcement for them to act upon what they think it is. And then I think the other part of the education is, what are red flags? What are some typologies for each of the sectors that you think there's money laundering going on? Is it organized criminal activity? Is it drug trafficking? Is it, immigration fraud? So each of those groups, as Peter can tell us, have their own kind of typologies that organized criminal activity or that just activity works under. So I think having an education where people understand what's going on with certain types of criminal activity will help them identify red flags way better, will help them provide better intelligence to FINTRAC. That will flow back to our provincial law enforcement agencies, will flow back to the regulators. and a lot better information for them to then, I think, work more efficiently with better intelligence to regulate what it is that they regulate. So for me, I think it just comes back to the basics, which is that what does the process of crime legislation say? What are you supposed to report? What does that mean in terms of the criminal code? And then how do you assist people to understand what it is that they're supposed to do in terms of reporting?
Yeah, it's certainly a lot more than just simply putting a manual under under an employee's nose and saying, here, read this. You know, the educators themselves have to really have a very clear idea of the type of message they want to get across to their employees and to senior management in terms of what to look for.
Yeah, but I do think, Norm, like a manual, we did one for a certain sector and it was 80 pages, and really we set out what the predicate offenses were and how you fill out a suspicious transaction report. And that's a little bit different than when you were asked to do a compliance program and a compliance plan. This is kind of a manual in plain language. Somebody comes into the bank and they say they're a member of Hells Angels. Okay, go to page 80. By the way, Hells Angels is an organized criminal activity. If they self-report, go to page 20, file a suspicious transaction report. What's your predicate offense? It might be any of these 5 things. So, a manual is a fantastic idea, a training manual on money laundering and what to look for to get people kind of up to speed and all on the same page to improve the quality of our reporting.
Here, 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 here.
No, Norman,
yes.
Could I just jump in at this point?
Please do.
Yeah, I don't disagree with what Christine is saying. Education and training are critical, and I know she does a lot of that. But I would say 2 things. One, and I've been harping on this for probably 30 years since FINTRAC was created, and being in Ottawa and in their offices shortly after they were created, there's a structural issue here that is pretty important. FINTRAC is an outlier among financial intelligence units around the world in that it is separate and apart from law enforcement. Law enforcement does not reside within FINTRAC, and that is simply because of Canada's privacy rules and charter. The net result, though, is that you have a structural disconnect between the people receiving the intelligence and the people that have to use it. And for many years, the police didn't know what FINTRAC had, and FINTRAC didn't know what the police wanted. And having been in law enforcement many of those years, I witnessed this firsthand. It's getting better now because they're putting a lot of, the problem has been recognized, and FINTRAC is doing a lot of outreach to law enforcement, and law enforcement is much more aware now of what FINTRAC can offer. But that divide still exists. That is not the case in the United States with FinCEN, which is law enforcement essentially runs it. It is part and parcel of the law enforcement machinery. In the United Kingdom, the Financial Intelligence Unit resides within the National Police Agency. So, and you can go on and on and on with other FIUs. So we have a structural problem. And that is exactly one of those issues that the Cullen Commission was not allowed to look at because it was a provincial inquiry. It goes back to exactly what Brock was talking about. The Cullen was courageous in that he said, despite what he's being told by counsel for the federal government, I am going to comment on various aspects. But this is a prime example of it. The other thing I would say is there are limitations on what we can expect people in financial institutions and so forth to recognize in terms of, let's say, predicate offenses and so forth. The problem, and I'll just, a quick example, cars. Auto sales are not a reportable item in under our legislation. So you can walk in, and we pointed this out in Dirty Money 2. It still exists today. You could walk into a car dealership with $250,000 cash or $500,000 cash, purchase a car, and there is no required reporting under the legislation. The dealer then brings that cash to a bank and says, here's 500,000, put it in ABC dealer's account. There is nothing illegal about that transaction. And all that the bank, the financial institution, sees is a long-time car dealer client who is depositing money. They do not have visibility on the point of sale. They could never know who it was that actually purchased that vehicle. It is a very routine transaction taking, well, not necessarily routine, but it is a transaction between a known client and a financial institution. So that gets to this separate issue entirely with universal cash reporting, which I won't go into, but it is an example again of these structural issues we've got with our legislation. Thank you.
And Peter, I'm going to follow up with a question on that as well. And just came in from Alicia Nahirni from the audience about suspicious transaction reports. She's wanting to know if education is enough regarding these, or should we really be expecting some sort of legislative changes that are going to help employees with filing or even recognizing what to put in an STR?
Yeah, I don't know if I can really add anything to my previous comment, which I think touches upon that question, in that I see structural issues, and the only way you can reform or change structural issues is to recognize them, then make changes, which would be legislative in the case of FINTRAC. And in terms of dealing with, there are what, 100,000 reporting entities in this country. To expect everybody to become an expert on money laundering, it ain't going to happen. So, there are limitations on what we can expect of people in the financial industry. So obviously it's up to FINTRAC to, provide information training, or private industries to provide that training, which is, very clear, but it's going to be basic, because, this is not a profit center for business. And it is that one thing that everybody has to do off the side of their desk, so forth. So, essentially.
I think really, Norm, if FINTRAC were to even, like when you fill out a suspicious transaction report, the section where they want to know, like the narrative section is at the very end. And I think if they even were to change it so that there's a drop-down menu where the bank employees filing, they're clicking the box on what they think the predicate offense is. So for one thing, they'll start to learn really quickly, oh, I have to identify predicate offense. And then if they click off, tax evasion, then I think when FINTRAC gets it, if it has actionable intelligence, it knows this is a CRA thing. And the same way, if it's securities fraud, okay, insider tipping, it knows to send this perhaps to the Securities Commission. So I think even just a little tweak like that on suspicious transaction reporting to improve it would, I think, save FINTRAC time and effort, and would make all of the reports that then go to regulators like improved and more actionable for them. And I think that would be a long way to improve the whole ecosystem with just that small change.
Nice suggestion. I hope the right people in the audience are out there listening. And one of the right people out there at the moment in the audience is Sandy Boucher, probably writing in from Toronto. Sandy has been one of our panelists in the past, and he certainly knows this topic backwards and forwards. And his question is, and I'll probably put this to Brock, what did we learn about the effectiveness of our whistleblowing laws and systems from the Commission, and what concrete steps have been taken as a result?
Yeah, good question. I think to be frank about it, I don't know that the report has a lot to say specifically on whistleblower legislation. I don't suggest that means it's not an important topic or something that needs to be better developed. I think the history of the work we did, in part, as you heard a bit of the earlier comments, came out of a significant sort of public awareness and political and public awareness and interest in the topic that came from newspaper reporters, initially investigative journalists, and then experts in the field and others leading up to the German reports. One part of what drove the journalism was whistleblowers, people who came forward and said, look, I know something, or I have seen and heard something, and I'm going to bring that to whether it's a reporter or another avenue. I think in the course of our report and the work we did, like a lot of things, there was a judgment call for right or wrong, and people will have different reasonable views on these things, but there are a whole series of judgment calls where we said, look, here's an area where we're going to go about it this way, and there's other important issues, but our focus is on the mandate, and that's what we're trying to do. And my own perspective on it is that we didn't spend a lot of time dealing with the overall question of what policy mechanisms should there be to protect whistleblowers, to permit people to come forward with proper ability to report on things that are problematic, but also that has to be done in a fair and a responsible way. It can't simply be reckless or angry individuals. So I suppose at one level that would stand in the category of things that the report didn't really take on to any meaningful degree, and that remains out there. Others may have different views. And then in terms of consequences or things that have arisen since the report, since the Cullen Commission finished its work and packed up and left, I don't know that I have anything to contribute specifically on the whistleblower topic.
Yeah, I know.
No.
Okay, yeah, sure. Go ahead.
Yeah, Norm, I'll just unabashedly plug the fact that the Vancouver Anti-Corruption Institute is hosting an international conference on whistleblowing at the Park Hotel in downtown Vancouver on November 8 and 9. Because as we know, when it comes to corruption, it's all about whistleblowers and journalists. And so we've already got quite a star-studded group of presenters. So I encourage anyone to take a look at our website. It's November 8 and 9. It's all about whistleblowing. And the reason why, in addition to what you've just heard, is the fact that British Columbia, has whistleblower legislation now, and virtually all of our Crown agencies are coming on stream this fall. And we're noticing similar types of legislation, public disclosure and interest legislation right across the country. So it's a significant issue. And there are a lot of people looking at it right now. Thanks very much.
No, can I make a quick comment?
Yes,
so
go ahead.
what's happening in the United States with respect to whistleblower, and specifically insecurities, fraud, I'll just talk about that, which is probably something I know a little bit more about. So what's happening is that there's kind of a divide, which I think is a really good divide between, are you whistleblowing pursuant to some legislation? In other words, are you whistleblowing pursuant to the law in a legally mandated fashion, or are you whistleblowing in a way that is not legally mandated, in which you're breaching perhaps some legislation of some organization you belong to? And so I think there's a really good divide happening where I think people are moving more towards a favorable outlook on this is legally, permitted whistleblowing versus, did you steal a bunch of documents and you're whistleblowing and you handed it off to somebody because you want to store it to run, which, perhaps there's some really good reasons why you might have done that, but all sorts of reasons why maybe it's not that great. The rule of law isn't prevailing, the protections don't exist. And so I think in Canada, one of the issues is with whistleblowing, at least, in the securities realm, except for Ontario, if you want to whistleblow, it isn't really a protected activity in the same way that it is in the United States. But I think, as Peter was saying, that's likely to be changing fairly quickly. So it's really interesting, but I think part of this probably came up with the Cullen Commission with respect to whether it was, legal whistleblowing or whether it was not. And I think you see this in the Facebook testimony that happened not too many months ago, where it was a legal whistleblower claim, protected, but nonetheless pursuant to some legislation, versus some documents from the NSA or, that whole situation that was a little bit different, where clearly there's some criminal issues with doing whistleblowing in that way. So it's really interesting to see things changing in British Columbia. And I think the Cullen Commission perhaps had the issue of, because the receipt of the information is the problem. Like, is that information legally acquired and obtained, or is it somehow tainted and you can't use it? So yeah, I think it's a really interesting point.
The climate of whistleblowing in general is changing worldwide, and as you mentioned, very specifically here in British Columbia. And I know Sandy, who sent in that question, would be mad at me if I didn't mention that it's incumbent on companies and organizations to develop proper whistleblowing channels, and also to develop, as best they can, an effective whistleblowing, or a speak up culture, so that people aren't afraid to speak up and they're not being penalized. And of course, that is internal penalties or external penalties in the form of legislation. And I know Sandy has been tireless out there in Ontario in trying to get better whistleblowing legislation implemented here in Canada. And now I want to throw moving on in the same direction with whistleblowing and education as means for the private sector to improve and strengthen their own anti-money laundering profiles. I want to throw sort of two questions to David and to Dawn. David represents realtors in British Columbia, and Dawn represents lawyers in British Columbia, both of whom, in those many years that I mentioned at the outset of this webinar, when everybody was running around pointing fingers at everybody about why money laundering is out of control in British Columbia and ruining things for all of us. Lawyers and realtors, for better or worse, were targets of a lot of those criticisms. Education works internally, as you can educate your realtors and educate your lawyers, but I think also educating the general public about these misperceptions or misconceptions. So Dawn, I'll go with you first. What has the Law Society of British Columbia done to, and continuing to do, to change this perception that somehow lawyers were holding millions of dollars in escrow funds on behalf of their clients and weren't checking for the source of these funds and were therefore somehow contributing to the runaway housing prices? And David, same situation with the realtors, that they perhaps were holding millions of dollars in unchecked funds and weren't even checking anything at all, and were allowing students to theoretically purchase multi-million-dollar mansions in Shaughnessy. So what have both of your organizations done to change this misperception on the part of the general public, and also the education and even whistleblowing programs that you've got in place to help your own members? So
sure.
It's a big question, but there you go.
Maybe I can jump in first on that, Norm, and I'll start with the misperception that you just articulated, that the Law Society represents the interests of lawyers in British Columbia. That's the Canadian Bar Association BC branch. The Law Society is the regulator of lawyers, and I think it's important for people to understand what I perceive to be a fairly fundamental distinction in relation to the respective roles of the CBA and the role of the Law Society. I wanted to also offer a couple of quick observations in relation to the importance of the Commission report and some of the work that have preceded it. It's been mentioned already in relation to not only the Cullen Commission, but the work that Peter German had done with the two reports, Maureen Maloney's work. Brock mentioned the work that had been done by Dan Perrin that I think was a significant part of all of this. All of that has contributed significantly to raising the level of understanding in British Columbia, not only amongst the professions, but also at a public level in relation to the significance of and the reason for the substantial concern about money laundering in British Columbia. And I think that has been incredibly helpful, not only domestically, but nationally and perhaps internationally. One of the upsides of COVID is that it's resulted in a situation where monthly I'm talking to my CEO colleagues in all provinces and territories in the country, and the Cullen Commission has been an area of significant dialogue amongst my colleagues. It'll also be a subject of discussion with the Federation of Law Societies of Canada at their meetings in October. I talked to the Commonwealth Law Secretariat in a webinar about the Cullen Commission a couple of months ago. It'll be a focus of discussion at the International Conference of Legal Regulators that brings together regulators from across the world. That happens in Chicago in October. But I wanted to talk a little bit around some of the things that I think people maybe don't understand are actually out there and that are distinguishable from perhaps other countries. In British Columbia, for example, the Law Society has a very robust reporting structure and an audit structure. All law firms are audited at least once every 6 years. Those firms that are considered to be, given the nature of some of their activities at a higher level of risk, are audited every 3 years. I think with the Cullen recommendations, we'll be looking at that even more closely about how we might refine some of the audit activity that takes place. We have an in-house group of auditors supported by forensic accountants and an investigation group, all of whom are trained in money laundering areas. So the degree of scrutiny that takes place in relation to how lawyers operate their trust accounts in this jurisdiction and in many other Canadian jurisdictions is really quite robust. I've been really quite surprised, spending time internationally, to see the extent to which those kinds of mechanisms simply don't exist in many other jurisdictions. So that degree of oversight that we kind of take for granted in this jurisdiction and where we pursue continuous improvement doesn't exist in many of the American jurisdictions and in many other international jurisdictions as well. So the degree of scrutiny and the oversight in relation to how trust accounts are operated is really quite high. We continue to see some violations of the regulations in relation to client identification and cash transactions. Not all of those fall within the scope. In fact, most don't. in relation to money laundering. Many of those are breaches of the requirements that are there in order to reduce the overall risk in relation to money laundering, something that Commissioner Cullen recognized as a significant attribute of the work that's being done here in BC.
And Don, I've just received a question just apropos to what you've been saying. This is from Jeffrey Simser, and he's saying that in Ontario, the Law Society has a role in training lawyers and paralegals. How does he go here? For example, don't allow your trust account to be misused by a money launderer. But the insurer does the training because the issues that create legal risks for a law practice are also money laundering issues. And will BC take a similar approach?
And we've actually been doing that. If you check out some video work that's done by Sue Forbes and her colleagues at the Lawyers Indemnity Fund, they're identifying some of the areas of risk all the time. Another one that I'd like to mention is some of the work in relation to what we need to do with respect to those coming into the profession and the role that the professional legal training course can play in helping to address that. I'd actually like to see law schools do a little bit more on that front. We have an evolving demographic in relation to those involved in the practice of law. And we're seeing a lot of people going off into practice on their own or with others of similar vintage early on in their careers. So I think we have to be much more attentive to making sure that people are armed with the knowledge that they need to have about how to manage their trust accounts. And there too, I see quite a bit of room in relation to some evolution in the way that we might do things. So for example, Commissioner Cullen made a recommendation that it should be mandatory that there be AML training for all lawyers who operate in areas that are considered to be of higher risk, whether that be with respect to real estate transactions, trust situations, the establishment of corporations. One area that he identified that I think is one that has not received the attention that it should is in relation to private lending. Whether we'll go to mandatory training for everyone, don't know the answer to that question yet. I think that's something that'll be addressed by the trust review task force that was established in the aftermath of the commission. But I think there would be at least quite a bit of merit to having a look at whether at least one responsible lawyer in each firm that operates a trust account should be required to take that training. And as we see the evolution of regulation and the move towards a single legal regulator, I think we have to incorporate some of the thinking about what kind of training is necessary, particularly with respect to the operation of trust accounts, as we see some potential expansion of who may have responsibility for operating those kinds of accounts.
Super. So that covers off the lawyer side. Now, David, the realtors and developers and whatnot in British Columbia over those many years had a lot of fingers pointed at them. What misperceptions has the BCFSA been able to alleviate or just discard? And what sort of work are you doing with the real estate industry at the moment in order to ensure that those sorts of complaints will just disappear?
Yeah, thanks, Norman. And similar to Don, we're the regulator and the industry voice and association is the BC Real Estate Association. I note that Trevor Coote, who's the CEO of the BCREA, is one of our participants. So we might quickly put him on the panel and then release him to answer some of this. But we introduced anti-money laundering courses for realtors and now for mortgage brokers as well. That's required for licensing and relicensing. That was done in 2020. And that's been quite a hit. I think some of our colleagues on at the Law Society have taken that course. I know the same at the notaries, and it's attracted quite a bit of interest. So I think the course has done well. That's to train the realtors. There are in the order, again, very rough number, but of 100,000 real estate transactions at BC annually, and of all of those 100,000 transactions, there's roughly 24 STR, suspicious transaction reports, filed by realtors in British Columbia, which seems light, hard to judge. After that course went up a little bit, but probably not a lot. So realtors, I think, would say that they only see 5 to 10% of the amount of money involved in the transaction, the deposit amount out of which comes their commission as well. Some of them, of course, would have a line of sight beyond that into what's going on. Others wouldn't. It's the deposit, and the rest is dealt with elsewhere. One of the things we did do, interestingly, this is back in 2016, before my time here, but it was introduced, speaking of whistleblowers, a tip line. And that our sense is that's an anonymous tip line. And our sense is it is mostly realtors, real estate licensees that use that line. We get several hundred of those a year. A lot of them you can't do much with because it's anonymous. You can't actually get off square one because you don't have the evidence you need in hand, or you can't gather the additional information very easily. But about a third of them, so 150 a year, actually bear out. Not all of those would be money laundering, of course. The majority are other things, and there may be mixed motives for that. But it has proved effective in drawing things out. An interesting feature, and this bears a little bit on what Don was saying, an interesting feature of the system of real estate regulation we have now is the existence of managing brokers. Every real estate licensee in British Columbia has to be under the supervision of a managing broker. And they're kind of a privatized realtor, or a privatized regulator, excuse me. So it's a difficult role. Some of them supervise like 100 licensees, so they're spread pretty thin. And that's being looked at, whether the system is really serving well or needs to be improved, can be changed, compliance officer possibilities, a whole lot of things. There have been some consultations on that, so we'll see what comes out of that. But it's that's an issue. It could be a point of within brokerages of achieving a higher level of compliance as well as education. Of course, the brokerages are reporting entities and have to have compliance programs subject to FINTRAC. So
Sure.
Thanks, Norm.
Okay, and here's a question from the audience from Jean Demira, which I'll throw right back at you. The real estate life cycle starts and ends at the purchase and sale stage. Why are utilities and municipal property tax authorities spared from third-party surveillance or risk detection to cover the monitoring of this life cycle of these crucial assets in financial crime risk? Why is this only borne by the private sector and not other public agencies or governments? And are they doing their part? And maybe Brock can even add to this. Did Cullen review this?
I don't think there's significant discussion in the report. There's a lot of discussion about real estate, and there's a number of recommendations in the real estate sector and findings, but to memory, I don't think it deals with the question about municipal property tax authorities. That was a topic we've had some awareness of. Now I'm trying to separate in my mind, which I'm not easily done, because a whole chunk of our work was preparatory and us getting up to speed and learning things and speaking with people, as opposed to what ultimately distilled into the evidence before the commissioner. So I've read about and heard about instances where municipal tax authorities are receiving surprising amounts of money, and but as to what the evidence was offhand, I don't remember. I think when you're dealing, there's a few sides to this, and I think the broader theme of the question is one that will recur in any number of sectors, which is, to what extent is the responsibility offloaded to the public, to the private sector by the government? And to what extent is that appropriate and fair? I have a memory of a statistic, it was put in a colorful way, which was along these lines. If you dealt with the amount of resources that the banking and credit union, that set of established financial institutions, the amount of resources they put in, would sort of be many times into dealing with anti-money laundering regulations and requirements, would be many times the amount the federal government puts in. It's sort of a shocking thing, and yet you have this just enormous, and I think the report comments on that, the enormous dedication of expertise and resources and effort to try to do that, and yet still a question of whether all of that is the best way of coming to grips with the problem. I think
Another topic for a future webinar.
Yeah, that's maybe a bit big picture, but I think that's a theme that sort of underlies that question.
Definitely. We have a question from, and thank you for that, Brock, much appreciated. We have a question from Samina Ula, and I'll direct this one to Peter because he's been very directly involved in this through his work with Transparency International Canada. Do you believe there is equal level of risk in money laundering in Toronto, for example, or any other Canadian city connected to international markets? And I'm thinking of the Transparency International report on snow washing.
Yeah, great question. And it's really nice that we've got a number of participants, obviously from Ontario. Nice to hear questions from Jeff Simser, who's a colleague over many years and really instituted civil forfeiture in that province, and Jean Demira, who's an expert on identity and methods of obtaining identity and client identification. So it's nice to hear from both of them. Yeah, there's no question that Vancouver is not alone in this. We've put a spotlight in some ways on ourselves, but I know that when I speak in Toronto and other locations in Canada, I just change my slide and say, hey, the environmental factors here are very similar to what we deal with. And, you know, take Toronto, for example, easy access to the United States. It is in that eastern seaboard, close to New York, which is the center of financial activity in North America. You know, you've got all very similar environmental, cultural factors, large diasporas, established organized crime. However, there are differences. So, for example, the organized crime in Vancouver is different from the organized crime in Ontario. Certainly, there's homegrown you know, biker gangs, there's Asian organized crime in both locations, but you've got the old style mob and in the Ontario region, which you really don't see any longer in Vancouver for a number of reasons. So there are differences, but and the federal issues that we've raised or the issues with FinTrack and resourcing of the RCMP and so forth, those exist right across the country. So yeah, by all means, we're putting a spotlight on ourselves, but that should not allow other provinces to really take a pass on this issue. And to some extent, that's what we've seen up to now. On the other side of the Rocky Mountains, a lot of people say, well, that's a BC problem, that's a Vancouver problem. You know, things are different out there. Not necessarily.
And that's terrific answer. And thank you so much for explaining that, because certainly I think people here in Vancouver, we tend to keep the blinders on. Oh, it's us only. Ontario has faced its own unique set of money laundering problems as well. The genesis of some of those problems differs from here in British Columbia, but certainly they're no less impactful on the economy there. Another question here.
Do you mind if I jump in?
Sure, please do.
I have that feeling. Usually I have this the day after I lose an appeal, which is I think of the answer I should have had. It's a little too late. But in thinking about Jean Demira's question.
Brock, you've never lost an appeal.
Oh, Peter, you'd be shocked. In thinking a bit more about Jean Demira's question and why it is that the report and why it is that there seems to be a great deal of focus on the private sector as opposed to the public sector in terms of addressing risk in real estate. And I think one part of that could be understood in terms of our best shot as the commission team at identifying where can we make important findings that are hopefully calibrated to risk, but also in light of our provincial mandate as a provincial commission. And sometimes that meant that we spotted issues. So maybe this circles back to the whistleblower. I like to think it's not that we were clueless about them, but that we simply made the judgment call. We can't disappear for a decade and burn up tens of millions of dollars and no one does anything in the meantime. We've got to get the thing done and get the report concluded and move on. So that's an example of something where I think it is fair to say there's not a lot in the report that deals with that. I think as part of the thinking behind it, the report talks about a common misunderstanding or misperception on the part of certain real estate professionals, that unless I've got a bad guy with tattoos, with hockey bags full of cash buying a house, I don't have money laundering. I know, I'm sure everyone here knows that may well be money laundering, but there's many more subtle forms of things that should be triggering a set of questions around what's going on and why is this set of facts and this person and this transaction presenting itself to me. And so the report spent some time in the real estate sector dealing with that, making recommendations to deal with that sort of misperception on the part of realtors in particular. So that's an example of something where I think it's more to say that that's where the emphasis was put as a result of our assessment of a larger risk.
Norm, can I just add to that a little bit? Brock mentioned something that I think is really important as something that happens in Vancouver and maybe North York. So just because somebody comes into the bank with tattoos, right, I guess is the point, doesn't mean that they're suspicious. So whether or not you report them or not depends upon, what you think their conduct is in terms of money laundering. But what has also happened in Vancouver, which is kind of a downside of us, being so overly concerned with money laundering, is one of the big banks decided to de-risk anybody who was an Iranian foreign national, who came in with their identity product that identified that they were born in Iran. So as you can imagine, they may have had mortgages, they may have had lines of credit, they may have had businesses, they may have had bank accounts, and they just decided that if you were Iranian born in Iran, I guess because they hadn't done due diligence with respect to really ascertaining who they were or if they were politically exposed or whatnot, they de-risked a whole group of them. So, a lot of them were scrambling to try to find bank accounts with another financial institution. But I think it's one of the dangers with going overboard with anti-money laundering procedures. So I think, part of what the Cullen Commission recommendations, I think, didn't say, but I think we're really careful in what they came out with is a balancing act. What are you going to regulate? How are you going to make sure that it's not an overkill? How do you make sure you protect people's rights to have a bank account? And they did mention financial inclusion to one extent. So I think it's really important, not to as well point about the tattoo. My God, somebody has a tattoo, they must be the Hells Angels. Maybe not. I think it comes back to what is the actual activity that somebody filing a suspicious transaction report thinks is the criminal conduct that warrants filing a suspicious activity report, as opposed to let's de-risk a whole group of people because they were born in Iran, which is kind of a way much of an over response, I think.
Yeah, great point, Christine. And my colleague John Ritchie has just sent in a question which connects directly to what you've just said. John asks, if a foreigner breaches his or her home country's foreign currency laws, could be China, could be somewhere else, and the mode of money transfer, such as, say, batches of 50,000 each or something, makes this obvious, does this become a reportable money laundering attempt?
I think so. I mean, it depends on the country. So in China, where I had done quite a lot of work, they do have criminal laws with respect to the exiting of money. So if you break their criminal law, so some of the, we talked about this on Friday, but some of the 50,000 reports, right, or 200 or $450,000 reports that some people are filling out with all of their employees to move $18 million or whatever it happens to be from China to Canada into one of our financial institutions. In order to have done that, typically what happens is, except for the first report, which is the person immigrating to Canada, the rest of the 399 $50,000 reports that they're going into a bank and completing is an instance of bank fraud. So you have 399 false bank reports where a person goes in who knows the Chinese foreign national, they go in and they say that it's their $50,000, that they're the ones wiring it, that it comes out of their bank account, all of which is untrue. So under the laws in China, bank fraud is a criminal offense. It's what we would call an equivalent predicate offense. And then that money gets wired into Canada. So how they got the money could be process of corruption, could be they committed bank fraud, which happens often enough with respect to the ties to Vancouver. So they committed some sort of criminal offense. I'm just saying in some cases, are moving this amount of money, violating the Chinese exit laws, that is a criminal offense in a lot of circumstances, and then they're moving it into Canada. And then I know that our banks used to take the position that, hey, look, we don't know what happened in the other country. It landed in a bank account. We only look at it from the moment it lands into a Canadian bank account to determine whether or not they've engaged in any criminal conduct in Canada. but it ignores everything that happened in the other country. And that really isn't the way either our anti-terrorism laws or our money laundering laws are supposed to work. They're supposed to be international facing and an analysis with respect to when the money comes into Canada. So it's hard to say. I think it depends on what country and how the money was moved into Canada to decide whether or not when it lands in our Canadian bank accounts, it may be the process of crime. And if you think that it is, then clearly it's a reportable instance. And I guess it raises the other question of, should the bank be accepting it in any event when you have $450,000 transaction wires, right? One after the other going into one bank account. Like, I feel like that is a reportable instance, if not 400 reportable instances in one bank account.
Yeah, so
You
to
can
help,
see-
yep.
Sorry, Norm.
No, please.
You can see how tricky the issue becomes. So because I agree with Christine's point. In that example, you've got identifiable bank fraud, and an extradition lawyer would say, well, that's double criminality. That's a crime here too. And we can sort of identify it that way. But what if you have one person moving money overseas? And what would be in modern times, the Chinese diaspora moving enormous amounts of wealth out of China? Is that not really the analog to what happened post-World War II with Italians, with the diaspora around the world and money that moved out contrary to Italian currency regs and made its way into economies all over and communities that built themselves up in other countries? And so at one level, I think it also points to the challenge that you have. And China's a good example, I think, for this. And Christine's got more expertise certainly than I do. But to the extent that anyone in Canada is trying to say what happened over there, and coming to grips with what the facts are on the ground in China is it can be challenging in terms of for a number of reasons, including the trust or distrust in the court system and the findings that may emerge. So I don't know where that takes us, but it's to say it's a very tricky, and it's also, I think, a very delicate issue, because it's sort of a hop, skip, and a jump onto the sort of thinking that you sometimes read in the comment section of the news sites, where people are saying, well, it's all these quote unquote, it's the Chinese people in Vancouver who have pilfered money and they've now bought mansions in Vancouver, and I don't like it. There may be some of that, but there's likely to be, in my guess, that it would be far less of that than those people think.
And if I could just,
yeah, I
was just going to, okay. Yeah, no, go ahead, Christine.
I was going to say it's a really good point. It's a really good point, right? Because clearly, if people are trying to exit a country and for whatever reason, it might make sense to not look at where exactly that money came from. Clearly, you're trying to, assist them to move to a different country. So I see that perspective. What they do in Hong Kong, what private bankers in Hong Kong do who have to deal with enormous amounts of money that might be of questionable or unknown provenance, they're saying, at least the AML people, as they go to the person in China, let's say, clearly it doesn't look like a Bill Gates shouldn't have, $40 million chilling in their bank account. And the saying they say to them is, take me to the first nugget of gold. And what that means is, show me in your books and in your business, and how, and many other ways you can show me that the money that you're wanting to move to Hong Kong to then move to Canada, whatever it happens to be in your private banking account, was legitimately earned. And if they can't bring them to the first nugget of gold, they don't get a private banking account. But I'm not sure that we do that in Canada, or that we have done that enough. I think that we just have accepted that maybe people are wealthy and we don't question the provenance of their wealth. And I think that's one of the recommendations, coming out of the Cullen Commission in a roundabout way, which is, if you have unexplained wealth, would you mind just please explaining it? Right. I mean, you should be able to if it's legitimately earned.
Yeah. So I could just.
Yeah, go for it, Peter.
Norm, just on this point. I mean, the bottom line is that money avoiding currency restrictions in other countries does not constitute an offense in this country, prima facie. So the issue is the transmission of. And as Christine mentioned, if it involves bank fraud, i.e. going through legitimate bank systems, and if people are lying about origin or any, of those issues, yes, it does potentially give rise to bank fraud. But if you look at the Vancouver model, which has been reviewed in the Cullen Commission and in my reports and so forth, and goes back to the work of John Langdale in Australia, the Vancouver model really involves the use of hawalas, as we call them, underground bankers, informal remittance systems. They can be connected to organized crime. And it's all about how the money is transmitted. The individual receiving the money at this end, be it the person who comes over from China, their income may well have been legitimately earned. They simply couldn't get it out of the country by some other means other than the hawala. And I would point out that there are some cases, interesting cases in Ontario now, or the Ontario courts, which are really saying, the hawala system may not necessarily be a bad thing, because there are a lot of people with a lot of problems in this world, and they're trying to get their money out for legitimate reasons out of various different countries. Not saying the hawala system is acceptable or avoiding bank regulation is acceptable, but the Ontario courts have made some very interesting statements recently about that very issue. So it really comes down to how this money is showing up. And yes, it looks suspicious. And in many cases, if a casino finds someone coming in with a bag of cash, they should be reporting it. And similarly with a bank, they won't necessarily know the origin. And that's for FinTech and the police.
But also, Peter, I think that then it makes me think of if the money's coming in through hawala, doesn't it trigger the requirement to report the importation of cash, which I think doesn't get done. So I feel like there's some legislation at some point that is supposed to be triggered with respect to, at the end of the day, somebody from a foreign country being in Vancouver with a large amount of money. Either it was an importation of cash that wasn't reported, or perhaps it was, a bank fraud, unfortunately, that occurred or didn't occur.
Yeah,
Okay.
It all depends on how the money comes in.
Yeah.
Obviously, if cash is being bulk transferred in, then anything over $10,000 has to be reported. But if we're not talking bulk transfer of cash, if we're talking about cash moving electronically through different means, then but the Vancouver model, no cash moved between countries.
Yeah.
That's why you had the underground bankers at both ends. Anyway, enough said.
Okay, so seeing as we're moving onto this particular discussion topic, and it's a terrific one. I'm wondering if some clarification, short of new and more effective legislation, some clarification could be provided to us, and to us I'm meaning more the private sector, by one or two of the recommendations of the Cullen Commission, which was the creation of an anti-money laundering commissioner here in BC, as well as a provincial dedicated intelligence and investigation unit. So I'll sort of toss that out to everybody. Would the creation of either of those two entities help to alleviate this little problem that we've been discussing here? Anybody dive in on that one? Brock, I know Brock, I mean, you obviously have some
Well,
you
my
probably have more
answer-
knowledge about this.
I don't know. My answer will sound self-serving, though. I mean, the commissioner in his report, those are two of the headline sort of recommendations. One is that the province should create an AML commissioner, an independent office of the legislature, with the idea being that for a long time in a lot of arms of government and regulators and agencies, money laundering is number 7 on the list of 10 things, or number 9, or maybe it's not even there. So the idea there is that you've got a sort of someone who spotlights this and who reports to the public and who liaises between different arms of government as well as industry and the private sector, and is sort of the repository of expertise, and reports to the public to say, well, look, at my focus isn't number 7 or 10 on the list, it's number 1, and here's what I can tell you about money laundering risks and so forth. Now, the wisdom of that, I sort of philosophically, and I think the commissioner would say, the report was his best crack at making recommendations, findings, and trying to help out. But of course, the fate of that, the commissions are strange for a number of reasons. One of them is we ceased to exist. We stopped having any existence once the report was in and the mandate completed. And it really does move over to those in government and the public sector and the citizenry and journalists to then track along. And I certainly expect there will be, I think it's a good thing if there's healthy public debate and disagreement about the wisdom of different initiatives. So I don't know that I'm well placed to pass judgment. I think it sort of moves into the realm of, will that measure help? The same too for the dedicated provincial police, law enforcement, intelligence and investigation unit designed to say, if it's the case that the federal model, and this picks up on things that Peter German's reports covered in terms of the RCMP engagement or failure to fully staff up, the engagement on money laundering specifically, and the demise of dedicated units that until about 2012, 2013 put a ton of work in. Is there a need for something more at the provincial level to have that dedicated expertise focusing financial crime and money laundering?
So, David, the British Columbia Financial Services Authority obviously has money laundering as one of its mandates, but you can't sort of be everywhere at once and be everything to all people. I know that money laundering is high on your list of priorities, but is it something that, you know, you're trying to deal with so many other issues within the financial services sector? Would an anti-money laundering commissioner, sort of, if it was separate from you guys, would it be helpful?
We don't actually have an express anti-money laundering mandate now. It's implicit because of the risks it brings, because of being out of compliance or committing an offense elsewhere. So it's implicit as a range of things. I'm not sure that would be of great assistance to us. What's of assistance to us is a specific mandate, and you know, and we're waiting, you know, with bated breath to see what the provincial government will be doing in response to the Cullen Commission. Of course, they're distracted with the premiership and so on. Just a couple of things. There have been public consultations on changes to the mortgage brokers and changes to money services regulations. So I don't think it should surprise anyone if those were sort of early up in the government's legislative agenda and may have something in there respecting money laundering. But it would be that that larger thing that czar in respect of AML matters in the province would be helpful, but probably not essential for us.
Okay.
We're looking for specifics. Yeah.
So Norm, I'll jump in on this one as well. And it's probably one of those occasions where I should make the statement that the views I'm about to express are mine and not necessarily those of the Law Society. But I think we have enough independent officers at the Legislative Assembly. So I'm going to approach this from a couple of different angles. There are many of the recommendations that the Commissioner made that resonated for me and that I think are very helpful guides in relation to where we go next. But if we're looking to actually see some things happen, I'm much more interested in what's in the mandate letters from the Premier to the responsible ministers that have an interest and a responsibility for matters that are relevant to AML. So I think in terms of real substance, that's more meaningful to me than having the addition of yet one more piece of infrastructure in the environment. Anything that might be done, and I don't know that an AML commissioner would assist with this. I think there are other mechanisms that would accommodate this, but finding the vehicles for a much greater degree of collaboration and cooperation amongst agencies is, for me, where the real opportunities lie. Could that be done through an AML commissioner? Possibly, but it wouldn't be the optimal choice from my perspective.
I'll be the contrarian here. I had not thought of that idea until I read it in the commission report, and I kind of like it because I think the whole idea is putting people and entities feet to the fire on this issue, and that includes that's government and private industry. That's my impression. So in David's case, if he doesn't have a specific mandate, but he should have a specific mandate, then it would be for this person to advocate for that. In addition to the advocacy taking place within government that David would be doing and his colleagues. And similarly, you know, we've got a whole lot of regulators over there, and the Law Society of BC has really stepped up to the plate when it comes to issues such as money laundering, but there's others that haven't. And, you know, that has to be pointed out. And I think, you know, I obviously, I don't know what Justice Cullen's thinking was, and that's really, you know, more an issue for Brock, but it would seem to me that after all the money that we've spent on this commission and all these other reports and everything, to basically let various recommendations sort of linger out there and not to have, you know, a holistic look at this and continue to drive it forward would be a mistake.
I think I would just add that I support the idea of a financial crime, commissioner. I think it's a really good idea. I think that it's a way of bringing all the stakeholders together. And if there needs to be a dialogue with Ottawa on, any number of things, I think it's a really good way to kind of streamline and have one person kind of do that. I'm not a fan of the FIU, BC version of it. I think that it's going to be expensive. I think it wouldn't be sustained. And I think the issue is FINTRAC, at least in terms of what the commission identified. And if they've identified an issue of unactionable intelligence, I think that AML person or the financial crime commissioner, to the extent there is going to be one, I think then it's their job. Go to FINTRAC and say, we need a person embedded in your agency, or we need some better intelligence. We need some more cooperation. Like, what is it that British Columbia needs as one of the provinces to make sure that it can improve in a financial crime perspective? And then that person, or when they get appointed, it's their job to go get that from FINTRAC instead of a FIU that I think will take away from FINTRAC's ability to actually deliver what we need from them, which is better, more actionable intelligence.
Yeah, Peter, you mentioned, thank you very much for that, Christine. Peter, you mentioned that there were some groups out there who necessarily weren't taking some of these recommendations to heart. I've had a couple of questions come in about CPAs. That perhaps could be a topic for another webinar, but perhaps Dawn could maybe answer this as well. The idea of regulating CPAs in this province, and certainly there are people who also had fingers pointed at them during the crazy years of anti-money laundering mania here in BC. And I don't just want to point fingers at CPAs, because I know there's other organizations and professional groups out there as well who could probably well do to have some sort of oversight. Is this something that we can be pushing for?
And you're directing that to?
Yeah, sure, Peter, sure. If you want to go ahead.
The commission report does talk about accountants, and that's not an area that has been dealt with very much in the prior reports. I didn't deal with accountants other than a peripheral reference. So it is very interesting to read that, and Brock might have some more to offer there. There are definitely some professions, like I said, that have stepped up to the plate, and others that haven't. But there's a reason why they've stepped up. I mean, I'm a very proud lawyer, but we have had lawyers involved in money laundering, and that's why this is a significant issue for the Law Society, and that's why they have been doing a lot. But the reality is, lawyers don't report suspicious transactions in this country. And if I had, one of my objections with, or not objections, but concerns with the report is that it does not encourage the federal government to continue looking at the issue of reporting by lawyers, although the Supreme Court of Canada left that open in its federation decision in 2015. The other point, since David's on the line, with regard to realtors, David mentioned, 24 suspicious transactions. Knowing what we know did go on in this province, is it because realtors aren't the right people within that industry to be reporting? Why only 24 reports? Where's the follow-up on that? So, it all goes back to, what we've been talking about, the need to have efficient regulations, not overly burdensome regulations, having regulators that are engaged. And I think that commissioner would be a great idea to point out continuing problems that might be there.
So you all travel extensively, I'm sure. You've all had a chance to, I know that Brock examined quite a few witnesses from all around the world during the commission hearings. Peter, you travel the world spreading the gospel, as does Christine. David and Dawn, I know you're in touch with your counterparts in other provinces. Where are we at in British Columbia vis-a-vis the rest of the world? I mean, do we have a pretty good model right now in terms of an anti-money laundering regime, both in the private sector and legislatively? I mean, or is there some other model out there, let's say New South Wales in Australia, just to take a random example, have they got it more figured out than we do? Or are we actually for better or worse, about as good as anybody. And I'll just throw that out to everybody, and then right after that, we're going to have some closing remarks from Carol Leal.
Well, I think we're moving in the right direction, but there's more work that yet needs to be done. And I think the commission report is very helpful in that regard. There will be some areas as we do that work where we'll continue to have some disagreements. Peter and I will continue to disagree in relation to the utility of lawyer reporting. I think it was significant that the commission recognized that solicitor-client privilege in Canada has constitutional protection for a reason, as does the duty to the client. So I think we have to be mindful of that. We lost a number of years in litigation as a result of the litigation between the law societies and the Federation and the Government of Canada. We've gone to a much better place with a working relationship with the Department of Finance, with the Department of Justice, with the RCMP, FINTRAC, and other entities. This is work that's led through the Federation and where British Columbia has significantly evolved. So I think that constructive dialogue is helpful in guiding some of the elements of where we can make some additional improvements.
Okay. Anyone else care to wave the flag of British Columbia on this one?
Sure. Except for lawyers, where I think, as we heard, there's been amazing improvements in terms of oversight. If you kind of take that sector out, I think that Ontario probably does a better job in reporting when it comes to banks, and it's just by virtue of the function of the fact that the head offices are in Toronto and they have, AML departments that are 600 strong in some cases, the ones that operate internationally. So that's an enormous amount of, little intelligence units that they have, and AML staff, and a lot of training. So I think that Ontario does a better job than we do when it comes to the banking sector, financial transactions, when it comes to MSBs, probably when it comes to even accountants. And I think British Columbia, we need to catch up a little bit when it comes to that sector. But I think overall, the rest we're all on par. And I don't know that there's any one jurisdiction really that stands out in the world. I mean, I think one of the things we realized from the commission's report, and even just being in the space, is that, we think there might be a perfect way to do anti-money laundering law, but there isn't. There's always going to be organized crime. There's always going to be risks. It's really just a matter of how do you mitigate it, and do you have the best practices with respect to mitigating it, like as a society, as a province, as a country.
My 2 cents is that kudos to BC for looking at this issue. Kudos to all those, the Cullen Commission, others, Don and Dave and so forth, who have been, making efforts. But my answer to the question is, ask us again once the recommendations have been implemented. And I can't allow Don's last comment to go without adding that this is not about solicitor-client privilege. I think we have at least 5 lawyers on this call, and we all believe in solicitor-client privilege, but other countries have been able to do this. And the United Kingdom being an example where you have a third-party professional body that receives reports from lawyers and other professionals. So I think there are other ways of looking at this. Thank you.
And many of those other jurisdictions don't have the degree of professional oversight that we have in a number of the Canadian jurisdictions. And folks, you can turn into any discussion that we have about this over the course of the next several years. And Peter and I will continue to carry on this.
And following on with the idea of strengthened jurisdiction, I think, David, I think you'd agree that this new and improved British Columbia Financial Services Authority, now that you've got a number of these agencies under one roof, is only going to strengthen the anti-money laundering profile from the legislative standpoint and regulatory standpoint in BC, at least of the sectors that you're covering. Is that how you see it?
Yeah, I think that was part of the view of government in doing this, and we give it I'll put it all in one place and create the possibility for a good focus here. And I think our consciousness that's been raised is above average in British Columbia as compared to the rest of the world, partly because of the work of Cullen and other things. But our methods and processes, probably aren't at the same level as our consciousness yet.
Fantastic. Panel, I cannot thank you enough for all of your insight and time that you've shared with us today. My apologies again for right at the beginning for arriving in such a huff, but we finally made it. We were all here. I want to thank you for all the time that you spent with me prior to this webinar. We didn't just sort of start this thing cold. We had a number of communications during the week previous to make sure that we were all knowing what we'd like to speak about and what sort of information that we would like to convey to the general public and to the private sector to allow them to take to heart some of these recommendations and findings of the commission in order that they could strengthen their own organizations, both as individuals and as companies themselves. So I just want to thank you so much for doing this. And now I'd like to turn it over, as I usually do at this time, to Carol Leal, who's an associate professor at UBC, and she's also a distinguished scholar with the UBC Sauder School, and she also is with the Center for Business Law at the Peter A. Allard School of Law at the University of British Columbia. So again, thank you, panel. Please stick around. We do want to chat with you for a few minutes afterwards, but Carol, you now have the floor.
Thank you so much, Norman. And I know we're over time, so I'll be quick just to say how appreciative I am to this panel for taking the time to share their expertise with us on this very live issue of money laundering in BC and setting the stage for the anti-corruption law program in this 4-part series on the Cullen Commission Report. I want to thank Don, David, Christine, Peter, and Brock. It was truly a star-studded panel, as Norman described it. Thank you for bringing your expertise and important insights today. As we all know, money laundering is opportunistic and adaptable, and the Cullen Report has a vast mandate. And when you think about it, the reach of money laundering is quite overwhelming. The report considered it across gambling, real estate, luxury goods, financial institutions, money services, including unregulated entities providing banking-like services, and the use of shell companies, trusts, securities, financial instruments. And for us lawyers, as you heard, also professional services and legal and accounting. I take Don's point in the need for law schools to ensure AML training, and I'm proud to say I certainly teach my students in their fiduciary duties to keeping proper accounts and not making secret profits and advising their clients and such, or they'll learn the hard way. But there's certainly room for improvement, I think, in our law schools generally. And the challenge now, and specifically with the report, is moving forward in implementation and ensuring effectiveness in those solutions, while also considering potential costs to civil liberties. It was Peter who said money laundering is akin to whack-a-mole, comes up when you least expect it. And the Cullen Commission's final report focused on institutional and regulatory changes in BC, but also made critiques and suggestions for improvement at the federal level. And as you heard, has had ripple effects beyond Canada. And the report was revealing in the new data it provided in its 101 recommendations. And there is a reason the anti-corruption law program knew this discussion needed to be stretched beyond one session and is really serving as a platform for broader discussions. And it's important for us to continue to allow the public to have access to education on these issues. It is an 1,800-page report, and the public needs to be able to evaluate the report's recommendations so that organizations and individuals can effectively address and combat anti-corruption within their own operations in Canada and abroad. You know, anti-corruption has always been a close, intimate study of power, and the anti-corruption law program has been on the cutting edge of this field of law for a number of years now, delivering free, public, and accessible information in this area. I just want to take a moment to recognize Norman, John Ritchie, and my dear colleague, Professor Emeritus Joe Weiler, and all the contributors and incredible team behind the ACLP, which the Center for Business Law, TI Canada, and iClear is so proud to support. You know, the conflux of intersecting crises that we're facing has certainly exacerbated corruption risks around the world. And this program really brings together so many experts and leaders in the field. And Don, David, Christine, Peter, and Brock, thank you again today, especially for your contributions in helping kick off this important series. The next 3 panels on the Cullen Report are going to be held on October 31st, November 22nd, January 19th. Over 100 of you registered for this event, which was announced only 2 weeks ago, and competing with the Queen's funeral. And that speaks to the demand and interest in this type of information and education. And as noted, a recording of this event is going to be posted online. These videos are free and available to the public, and has been the case in past events. There are often hundreds and sometimes thousands of post-event views. Thank you all for coming on behalf of the ACLP and the Center for Business Law, Transparency International Canada, and the Vancouver Anti-Corruption Institute at iClear. If you want updates on upcoming events, please sign up for the ACLP newsletter, which is available online and has been posted in the chat. And certainly sign up for the Center for Business Law, TI Canada, and iClear mailing lists as well for future opportunities and events engaging in anti-corruption issues. We are grateful to you all for coming. Thank you again, and goodbye, everybody.